All right, let's jump right into it. Today we are tackling the ultimate, definitive masterclass on the South African legal profession. Think of this explainer as your ultimate exam prep guide. We're going to take a ton of dense, nitty-gritty details, definitions, and concepts, and categorize them so perfectly that they'll slide right into your mental filing cabinets. Seriously, we are leaving no stone unturned here. So grab your mental highlighters and let's decode this massive chapter together so you can absolutely ace it.
Okay, here is our roadmap for today. 1. Intro to the legal profession. 2. Private sector legal careers. 3. Public sector legal careers. 4. Legal fees and representation. And finally 5. Ethical rules and court etiquette.
Section 1. Intro to the legal profession.
Now, historically speaking, the legal profession is known for being extremely traditional, right? You'll literally see this in their super rigid forms of address, like having to refer to a presiding officer as your worship. It's very formal. But how do you actually get your foot in the door of this traditional world today? Well, back in the day, South African universities offered totally distinct separate degrees depending on which specific legal profession you wanted to pursue, but that's been modernized. Today, all of those have been completely replaced by a single, comprehensive 4-year LLB degree. And by the way, LLB stems from the Latin Legum Baccalaureus, which translates to Bachelor of Laws. You definitely want to remember that. That one 4-year degree is your golden key. It opens the door to all the different legal paths.
Let's move on to Section 2, Private Sector Legal Careers.
The private sector in South Africa rests on 2 absolute foundational pillars, the attorney and the advocate. You have to know the difference. Think of the attorney as your general practitioner doctor. They're the first point of contact. Clients literally just walk in and approach attorneys directly with their problems. Most of them practice in firms, though some fly solo. And today you even get highly specialized attorneys. Now, contrast that with the advocate. Advocates are specialist litigators who spend most of their time arguing in court. Historically, there was a strict rule. You couldn't just walk off the street to see an advocate. An attorney actually had to brief them for you. But the Modern Legal Practice Act, or the LPA, has completely updated this, meaning advocates can now, under certain circumstances, see clients directly.
And speaking of major changes, there is a totally crucial piece of legislation you absolutely need to unpack and memorize. Act 62 of 1995. Specifically, this is the Right of Appearance in Courts Act. Now, traditionally, attorneys were not allowed to appear in the High Court or the Constitutional Court. That was strictly VIP territory for advocates only. But Act 62 of 1995 completely changed the game. It allowed an attorney to officially apply to be granted the right of appearance in these higher courts. It was a massive, fundamental shift in how the entire private sector operates. Okay, so building on that base attorney qualification, we find a very specific role, the conveyancer. A conveyancer is not just your run-of-the-mill attorney. To become one, you have to pass the standard attorney's admission examination plus a highly advanced examination. And what do they actually do? Look, whenever you see or hear the word conveyancer on a test, I want you to instantly associate it with one phrase, the transfer of land, like legally registering the sale of a house. So lock that in. Advanced exams plus transfer of land equals conveyancer.
Right next door to the conveyancer, in terms of specialization, is the notary. Again, just like the conveyancer, becoming a notary requires that attorney's admission examination plus an advanced examination. But you have to contrast their job directly with the conveyancer. A notary does not deal with transferring land. No way. A notary's distinct specialized focus is entirely on drawing up special types of documents. A perfect example of this would be drafting an antenuptial contract before a couple gets married.
Just to quickly sweep up the rest of the private sector roles, we have legal advisors and office personnel. A legal advisor specifically works to provide legal advice to a single company or organization rather than taking on random public clients. And of course, literally no firm runs without its vital office personnel keeping the lights on.
Section 3, Public Sector Legal Careers. Now, the public sector is this dense, crazy web of hierarchies and super specific functions, so let's break it down into an easy cheat sheet. First up, prosecutors. The top boss charged with instituting criminal proceedings is the DPP, the Director of Public Prosecutions. The DPP then delegates their authority downwards. They delegate to state advocates for the high courts and to public prosecutors for the lower courts. Next, we have presiding officers, which is just a fancy term for judicial officers. In higher courts, they are called judges. In lower courts, they are magistrates. Then we have the state attorney. Please do not confuse them with regular private attorneys. State attorneys are civil servants, and their clients are solely state departments. Finally, compare that state attorney to the state legal advisor. The advisor's job is highly analytical. They do the heavy legal research, they draft brand new statutes, and they give advice to state departments. Okay, so behind all those frontline roles is the administrative backbone of the courts, and differentiating these three specific titles is an absolute must for exams. First, the Registrar of the High Court. They are appointed to each high court to handle all the admin and documentation. Easy enough. Then you have the Clerk of the Court, who does the exact same administrative functions, but specifically for the lower courts. Then you have the Master of the High Court. There is a master for each provincial high court, and their focus is distinctly on specialized affairs. Think things like handling deceased estates. So, recap. Registrar is high court admin, clerk is lower court admin, and master is high court specialized affairs. Got it? All right. There are 7 final public sector professions you need to commit to memory. To make this super easy, let's group them together. Group 1, the registrars who handle documents. That's the Registrar of Deeds and the Registrar of Patents and Trademarks. Group 2, the protectors of rights. That includes the Family Advocate, the Public Protector, and the Human Rights Commission. And finally, Group 3, the thought leaders, the Law Reform Commission, and the legal academic. Memorizing them in these 3 buckets makes it so much easier to correctly identify them as public sector roles on a multiple choice test.
Moving to Section 4, legal fees and representation. We are pivoting now to a very real-world topic. How do these legal professionals actually get paid, and how on earth do everyday citizens access them? Well, the amounts that lawyers may charge are actually regulated by statute and by the profession itself. Generally speaking, attorneys and advocates are paid per hour for consultations and per day for court appearances. But here's the critical, stark takeaway from our source material. While these fees might appear totally fair to the profession based on the complex work being done, they remain completely out of reach and entirely unaffordable for the average South African. This tension between fair pay and public access is a massive central theme to understanding the whole legal system. So to combat this enormous cost barrier, we turn to Section 35 of the Constitution. You have to know Section 35. It guarantees an accused person the right to appoint legal representation of their choice at their own expense. But crucially, and this is the big one, Section 35 further dictates that an accused must be afforded legal representation at the state's expense if a substantial injustice would otherwise result. Obviously, this constitutional right places a massive financial and practical burden on both the legal profession itself and on state funds. So how is this state expense and legal aid practically delivered on the ground? The source material outlines 7 specific forms. Let's decode the Latin terms first, because they always show up on tests. 1. Pro Deo, which means for God, and refers to free representation for major serious crimes. 2. Pro Amico, meaning for a friend. 3. Pro bono, meaning for the public good. Then we have the 4 institutional structures. Number 4 is the Legal Aid Board. 5 is legal aid clinics. 6 is advice bureaus. And 7 is the public defender. Just memorize those 7 exact categories. Finally, Section 5, ethical rules and court etiquette. Listen, the consequences of failing to comply with the rules of this profession are incredibly severe. First and foremost, every single practitioner must be considered a fit and proper person. If you fail to comply with ethical rules, you face harsh disciplinary sanctions, namely getting suspended or being completely removed, struck from the role of practitioners entirely. It's game over. Furthermore, your relationship with your opponent has to be grounded in absolute respect. You refer to them formally as my learned colleague, and you strictly attack their arguments, never ever their personal character. Court etiquette is also highly ceremonial. You have a strict duty to wear specific robes, to bow when you enter and leave the court, and to stand when addressing the judge. All of this is designed to respect the dignity of the court and maintain the public's confidence in it. And regarding the state itself, every practitioner has an overarching, non-negotiable duty to uphold the law and further the administration of justice. But perhaps the most vital and sometimes complicated relationship is with the client. As the foundational rules dictate, and I quote, "This duty does not mean that the attorney is bound to do whatever his client wishes him to do. However much an act may be to the advantage, profit, or interests of a client, if it is tainted with fraud or is in any way dishonorable, the attorney should be no party to it. He must manifest in all business matters an inflexible regard for truth, and he must serve his client faithfully and diligently." Essentially, an attorney is not a hired gun. Participating in fraud or dishonorable acts is strictly forbidden, literally no matter what your client demands of you. So let's synthesize this massive amount of information into a spicy exam-style scenario. If a practitioner handles land transfers, which, as we know, instantly makes them a conveyancer, but they act with fraud, what happens? Well, they lack an inflexible regard for truth,
which means they are no longer a fit and proper person. Result? They get removed from the role. They lose their career. It actually brings up a fascinating final thought for you to chew on. In a system where legal fees are largely unaffordable to the masses, are these incredibly strict ethical rules the ultimate protection for the everyday public, or are they just another layer of traditional gatekeeping? It's definitely something to think about as you review all these concepts. Best of luck organizing those mental filing cabinets, and I'll catch you in the next explainer.